Shalom. Welcome to the Jewish View. My name is Rabbi Nachman Simon with the Chabad House of Dalmar, together with my co-host Mark Voronich of Statewide News Service, jbiztechvalley.com, and now columnist for the Jewish Press.
Right, and today we are going to combine law and Judaism in a fashion, and we have Rich Ancowitz here. He's a staffer in the New York State Assembly, but also is a private practice lawyer. And welcome to the Jewish View. It's great to have you here.
Good afternoon. Pleasure to be here.
Yeah. So, Rich, tell us your specialty is something about false claims or something, or?
Yes, there is a federal law that's commonly referred to as the False Claims Act that is used by whistleblowers, that is people with typically inside knowledge of fraudulent conduct where the government gets ripped off. And this law goes back until the time of Lincoln, when it was originally enacted, but it was juiced up in 1986 to allow citizens to be whistleblowers, and if litigation against the wrongdoers, the fraudsters, are successful, then the citizen whistleblowers can get a percentage of the recovery, between 15 and 30%. And depending on the nature of the fraud that's exposed, this can add up, as you can imagine.
A big contractor of a corporation, it could be, millions of dollars that are...
Well, yeah, we've all heard stories about the proverbial $900 toilet seat that is sold to the Department of Defense, for example.
Yeah.
And there's actually a lot of toilet seats that are sold. And if the toilet seat really is worth $5 and the government is paying $900, well, obviously that's a fraud that should be stopped. And there's actually quite a bit of that goes on.
But false claims and fraud, are you using those terms interchangeably?
Just about. Legally, they don't mean exactly the same thing,
Right, that's
but
why.
practically speaking, they do mean the same thing. The textbook definition of fraud is that there has to be an actual intent to deceive. Well, in this case, the intent in the False Claims Act doesn't quite reach that level, but for all intents and purposes, they are roughly equivalent.
Well, aren't people maybe, what would you say, still scared? For example, I'm talking about the average person. He's in the plant or he's an accountant and he sees something wrong, says, hey, if I say something, I know I'm going to be fired. It's a decent job. Then I'm going to have to sue, and I don't know. You could tell us the whole process, how many years it would take. And, I'm saying people are still maybe very reluctant to whistleblow.
Absolutely. Although built into the False Claims Act are very strong what we call anti-retaliation provisions, such that if an employer goes after an employee for so-called blowing the whistle against them, or anybody else for that matter, then they can be held liable and responsible for damages for retaliating against them as well. But what we also find is that sometimes people who are retired, they're excellent whistleblowers. They know sort of where the bodies are buried, for want of a better term.
Mm-hmm.
So they can't get fired anyway.
Exactly.
So they're not scared.
So, you talk about the $900 toilet seats, and if someone can get, shouldn't the free market bear its, if you can get $900 for a toilet seat that's worth $5 and you find a schmo who's willing to pay it, why can't you get that? You're not being deceptive. You have a receipt. You give the receipt that said paid, and you...
What typically happens in the real world, though, is that the toilet seat is represented as being something other than it really is. So there usually is some amount of deception or confusion that allows these actions to go forward.
But confusion's not illegal.
No, confusion isn't. But on the other hand, and you're quite correct. The bar is set fairly high in order to be able to establish one of these cases. But there are many examples of cases like this that succeed. In fact, just yesterday, the New York State Court of Appeals came out with a decision where a whistleblower had brought a case to the New York State Attorney General against Sprint, the telephone company, alleging that Sprint didn't pay all the taxes that they should have paid. And the amount in dispute here involves hundreds of millions of dollars, potentially. Sprint moved to dismiss that case. The court said no. They took an appeal. The appellate court said no. And finally, they took it to New York's highest court, the New York State Court of Appeals, which said that no, Sprint's defenses, at least preliminarily against this action, would not allow the case to be dismissed, and that case will now go forward. So there are, although there are certain procedural hurdles for lawyers and for government to navigate, and this is a public-private partnership,
Yeah.
whereas the private lawyer works with the government lawyer, in this case the New York Attorney General's office. It can also be the United States Attorney's office and the
Right.
Department of Justice in Washington. They work together in order to try to get the government their money back, and then some, because there are also penalty provisions in the law.
You as a private attorney help that out also? I mean, that's
Yes,
what,
that's what I do. There are, in fact, the way the law is written, a citizen can't bring this type of an action without getting a lawyer and without actually filing papers in court. For example, if a citizen was to just pick up the phone and say, and call, for example, the Inspector General of the Health and Human Services Agency in Washington, D.C., and say, hey, I've heard of this fraud, and this is what it's about, and da-da-da, and I'd like to get a piece of the recovery, they'll thank them for the information, but they won't be able to do anything else for them unless an actual lawsuit has been brought.
Wow, that's amazing that, you have to go through that documentation of the lawsuit.
And the
in
interesting
order-
thing-
Instead of just a phone call. It's different on the state level, though, isn't it? If you call the state attorney general, or if you call the inspector general, they would investigate it on their own?
They will investigate all tips, and they'll often do a very good job investigating all of this, but insofar as the person who is given the tip in the first place, they won't be able to do anything for that
The
person.
attorney general can file a lawsuit.
They can and they do on their own,
Right.
but that will not
If it's warranted. yeah.
that will not benefit the person the whistleblower, the person who provided the
Okay,
information.
Well, why would the
30%.
person who's the whistleblower have to benefit?
No, they don't have to
They don't
benefit.
have to benefit.
They don't have to benefit.
No.
But it's interesting, though, because employers now have gotten pretty sophisticated and pretty smart about this. What they're doing is they're saying to their employees, as a condition of your employment, if you see fraud, you got to tell us first. Can't tell anybody else. You got to tell us. And good employees, they hear this and they think, oh my goodness, I have to do what my employer says. But the law is not thus. The employer still has, the employee still has the absolute right to bring the matter to court and bring the matter to the appropriate investigatory authority, such as Department of Justice, U.S. Attorney's Office, New York State Attorney
So when you
General's
get
Office.
the employee handbook, you could just cross that out and initial it and say this is not
Well, I don't
something
think the
before you
employer.
sign that?
I don't think the employer would like that, and the employer would certainly raise a red flag to the employer. But really, the employee need not, and obviously, it's not for me to provide legal advice to any of your viewers. Every case is specifically determined on its own facts. But on the other hand, it would be my considered opinion that such a clause or provision in an employee handbook would be invalid.
Yeah, so you could just come prepared and let your new employer know that you know the law. And
they won't hire you.
And you may
too
not get
fast.
hired.
Yeah, I know.
That's the way the world works.
That's right. So
So-
that's the way it goes.
But it's
Keep
good
it
for
going.
people to know their rights, and you are helping people tell people what their rights are today.
So tell me what else false claims.
Well,
another
the important thing to know about
Yeah.
false claims, and what really I think people don't know, is the amount of money that's involved. It's really billions and billions of dollars. In a calendar year, for example, there are statistics that the Department of Justice puts out. For example, in the last calendar year, there was $5.69 billion in false claims recoveries that went back to the U.S. government, and approximately half of that was the result of citizen whistleblower cases. So as former Senator from Illinois, Everett Dirksen, reputedly said, $1 billion here, $1 billion there, pretty soon you're talking real money. So you've heard that before. So, but it really does amount to a lot of money, and it's not just defense contractors, for example. It's pharmaceutical companies, it's healthcare providers, hospitals, doctors' offices. Medicare and Medicaid billing can often be kind of tricky.
Automobile insurance, right? Fraud?
Well,
Is
automobile
that false
insurance
claims?
fraud is a different story,
Okay, so
because that typically doesn't involve the government.
Well, but there's a lot of fraud in automobile insurance. I mean, when you get into an accident and you file a claim with your insurance company, and then you don't get the car fixed, or you don't get it fixed to the standards it's supposed to, and you're pocketing some of the extra money. I mean, that's not exactly highly legal.
No, but that, and as you may know, I've written a book on automobile insurance, which is used widely by attorneys.
You and Ralph Nader.
Used by attorneys and claims adjusters throughout New York State. But that's a different type of fraud. That's fraud against an insurance company. And there are certain tools that insurance companies have that are different than the tools that the government has in order to address that.
So the False Claims Act is really a government-oriented
Yes, yes,
provision?
yes,
Okay, so there's a lot of fraud in the private sector, too.
correct.
See, when you brought up the toilet seat thing, I didn't necessarily register with me that it just seemed, yeah, I know you said it was the government, but it wasn't necessarily, in my view, it was a private company that was selling to the government.
Right.
And if the government is silly enough to pay $900 for a toilet seat and is confused about what their what their invoice reads, and they're not willing to look at this more deeply, and they have unqualified people working for the government who can't read these invoices, then you shouldn't, then why is the private company being harmed
I don't know.
by this? I just
there's-
don't get that part.
I know a person working for the Defense Department, and, we once talked about the toilet seat, his famous case, that's what Richard said. But he says, he says there's thousands, probably millions of how many planes that they're buying for the defense,
Right.
and tanks, and just
You're
even the
welcome.
military.
Yes.
So he says certain times, what I'm saying, you got every line, so once you see something, you spot it, oh, I see it, but if it's within 10,000 different articles, so it gets slipped by you also. So it's not like you're making so stupid, this what a person said, that it just gets slipped by you also. They can just
Sure.
stick it in a line within 10,000 lines, and maybe no one sees it. Okay, here's a few thousand,
Sure, and
no one sees it.
on that score, if I can address Mark's point.
Lift your microphone up a little.
Oh, okay. If I can address Mark's point.
Yeah.
A common refrain that businesses will say, and the U.S. Chamber of Commerce has been out front on this, is, oh, gee, if we make a mistake in billing the government, it could be an honest
Right.
mistake.
Why is it
Why
a
should
crime?
we bill? Why should we be held accountable? That's a common refrain that business says, but that's not the way the False Claims Act actually works. The way mere negligence or sloppiness, unless it's perhaps gross negligence, is not going to be enough to allow for a recovery against the business. You have to be able to show, and this can be done by patterns, but you have to be able to show typically an intent to deceive, an intent to knowingly submit a billing which is false or incorrect. And there are ways to do that with statistical evidence that the courts have allowed. And you don't have to go through every single claim amongst millions of claims. So it's an interesting area of law. It's an area of law that I find that most lawyers don't really have much of a clue about. But I think lawyers, especially lawyers who are representing businesses and lawyers who are representing employees, they're starting to get to understand it. It's only been since 1986 when Senator Grassley in the United States Senate, as I alluded to earlier, really amped up the law, which, as I said before, goes back to the time of Lincoln, to allow for these citizen lawsuits. And the law has been amended in Congress since then to make it stronger, to allow more protections for whistleblowers and employees. And then let's fast forward to 2007, when in New York State, after a number of efforts by New York State Attorney Generals, such, I think, going back to Dennis Vacco, and including Andrew Cuomo, and all the way up to Elliot Spitzer, for sure. The ball really got rolling with Elliot Spitzer. And up until the present Attorney General, Eric Schneiderman, who actually sponsored a bill when he was in the Senate to improve the False Claims Act. So he was involved in this for many years. Now we have a law in New York State, which really people can be proud of, and it allows New York State to go after, for example, under-reporting and under-billing of taxes. Under federal law, that can't be accomplished. The whistleblower provisions that the IRS have are very different, and up until only a couple of years ago, they were really not used very often. But under New York state law, and we've just seen with the Court of Appeals case from yesterday in the Sprint matter, there is the potential now for New York State to recover hundreds of millions of dollars in underpayment of taxes. Let me give you another example of a false claims case that attracted some attention in the New York Times, I think about 2011, 2012, where a doctor by the name of Feldman was an internist working for an agent that was employed by the city of New York looking at Medicaid claims. And he discovered in a fashion that New York City was not submitting Medicaid claims to the federal government in the proper amounts, that they were basically allowing for overbillings of Medicaid claims. As you know, Medicaid is a state and federal partnership, and the federal government ends up paying 1/2 of all Medicaid claims. So he determined that, gee, this doesn't look right, and he brought it to a lawyer. The lawyer brought it an action in court. An action in court was the city of New York moved. They were the defendant. They moved to dismiss the case. That motion failed. The case proceeded on. And a short time later, the case settled for $70 million, of which Dr. Feldman received $15 million. I think $14.9 million to be precise. So there is the potential for these cases to become rewarding, so to speak, for the person who brings the fraud to the attention of the government. And that's why I call these win-win type cases.
Well, then Dr. Feldman had to pay his attorney who he brought into the case.
I think Dr. Feldman was satisfied with the result,
Yeah.
and he did well with it.
But the lawyers always make out in these.
Well, you say make out, lawyers do work for
Yes,
these. I mean, these are not...
free time, yeah.
Yeah.
Right.
So,
And a lot of times they take it on contingency, right?
yes, and they invest a lot of work on it. And in fact, very often it turns out that the lawyer does a lot of work on the case and doesn't get anything because the case doesn't succeed.
Right.
But in any event, so Dr. Feldman's case is just an example of the type of case where just any Tom, Dick, or Harry or Joe Blow can succeed just by bringing information to the attention of government. You see, with ordinary types of litigation, you are entitled as a plaintiff, as a person bringing a lawsuit, you're entitled to be compensated to the extent that you yourself were damaged. This is different. The plaintiff is not damaged him or herself.
Right.
This is the government who's been damaged. So the amount of the recovery really depends on the extent to which government was damaged. So that's why these type of cases are different.
So who paid the $70 million?
The city of New York.
City of New York, because they were underreporting.
The city of New York allowed Medicaid claims to be paid, which were deemed to be excessive. Okay, in other words, certain providers and or recipients.
Certain doctors' offices or pharmacies.
It's a little more complicated than that, but that's the general thesis. And that's what happened. And as a result of Dr. Feldman's actions, there was that type of claim, that type of false claim stopped.
So what safeguards are put into place now after Dr. Feldman's suit to stop this from happening again?
I don't know specifically, but I can guarantee you that there are such safeguards. No business wants to get burned a second time, and no government, city government, wants to get burned a second time by having the same thing happen all over again.
Mm-hmm. So was that a one-time, did the city of New York have to pay it all in one sum, the $70 million, or was it paid out over time?
I don't know the particulars on that, but you can rest assured that they paid it.
They paid it, okay.
Yes. And if I could also allude to, and we were discussing this earlier, just from a tzedek point of view, a Jewish point of view.
Fine, we wanted the Jewish view. We like to hear the Jewish
exactly, and I'm certainly not learned in this regard like you are, Rabbi Simon. But I think the first employment laws really go back to the Torah, where it is clear that if you hire a work person, you must pay them their daily wages on time, not 5 minutes later. And so we really can go back to the very beginning in terms of employee-employer relationships.
I really appreciate your outlook on it because it's my theme many times that Judaism has been around for thousands of years, and Jewish people have been in Western society and other society, obviously also Africa and Asia. But even let's talk about which we know about is English law and Western law, and surely in the United States. How much law has been incorporated from Jewish law? Because sometimes I talk about with ethics, the idea of giving charity, the heart fund, the lung fund, a million funds. But how much, they say, well, that's normal. What's Jewish about the heart fund? Or like this, employee rights. It doesn't say in the law books, well, this is for thank you to the Jews for giving us this. But if you look back, as you have, is that you see that the original laws are Jewish, and it was really radical news in compared to the societies where they were living in, because they didn't have these laws. People would be paid in slave labor, that kind of idea, and you got to be fair to your employees. And then it was incorporated through time because the Jewish people were there and they're lawyers like yourself, and they're influential in saying, hey, we know what, like you say, tzedek for our viewers means, which is what is right. You got to be right to your employees. And the Jewish people said, hey, let's incorporate in secular or Western law these ideas that we have already in Jewish law.
And I think the abolition of slavery is even an extension of that, taking it even further. And that, again, had its genesis, no pun intended, in the Torah.
It's a good pun over here. But you're right. There's certain things, how much, really, you can go through history and how much Jewish influence. Certain things, obviously, Christianity is based on Judaism, Old Testament. That doesn't take any major research, to say the least. But just, I'm saying, even secular law, or like I say always with the idea of charity. Hey, people are down and out. People would say, tough luck, you're a loser, you're poor, you're a beggar, get lost, you're just a leech on society. In Judaism, hey, take it easy. So he's down on his luck to, help the guy out. And, that's today. Even the United States government, food stamps, stamps, welfare, how much charity, or even people privately, heart fund. A person's sick, take care of the guy, just don't throw him off the edge and saying, oh, drop dead, who cares? You're just a leech on society. Senior, we can go on and on. Senior citizens, the venerable seniors, now they're old fogies, get lost, just get away from us. Again, in Judaism, there's a lot to say. So the idea of being what's right, employees, but employee rights are still a fight that I guess you're still keeping up with.
Well, I hope so. I like the idea that I was able to go to law school. I was very fortunate and get an education in these matters. I certainly don't have your education in Torah and Talmud, but at least I'm able to take basic steps towards ensuring that people's rights are protected. And I feel good about that.
Now, I get the sense with this False Claims Act that it does not cover government waste and mismanagement. How come?
No, that's an entirely different problem.
Right.
And I can't claim to be an expert in that, so I'll have to leave that to more learned people than I.
Oh, okay.
Something for you to, Mark, to look into
I'll
as
look
an
into.
investigative reporting.
Okay. And what is a quitam suit?
It's pronounced Ketam, typically, Ketam.
Sounds more Chinese to me, or Asian, but it's Latin.
Actually Latin.
Yeah.
And as you probably know, there's a lot of Latin scattered throughout legal terminology.
Right.
But really what it means is, and what it represents, is citizens bringing an action on behalf of the sovereign, on behalf of the king, actually, on behalf of the state. So a Ketam action is an action that is brought by an individual on behalf of somebody else, and in this case, the state or the federal government.
I see. So what happens after that Ketam action is filed?
Well, the action is filed, and by the way, these actions are filed under seal. So what that means is they are secret. To give the government, after the action is filed, it gets brought to the attention of the government. In other words, filed in court, okay, but not served on the prospective defendant, on the prospective fraudster. It's filed in court, and then it gets brought to the appropriate governmental authority. The governmental authority then gets the opportunity to investigate. And these investigations, they can take a little while because the government has to do their due diligence in deciding whether or not they wish to get involved further in the litigation. And that's typically how it works. The government decides that, and if the government decides to get involved, and of course they have limited resources and they pick and choose their spots, they can get involved in the litigation and litigate it themselves. They can litigate it along with the whistleblower, or if the government doesn't want to get involved, the whistleblower has the right to litigate it him or herself.
But can the whistleblower keep their identity secret?
Well, the identity stays secret up until the time that the government decides what they want to do. So at that point in time, the case becomes unsealed, and then and only then is the defendant, the fraudster, aware of what's going on. The whole idea behind the secrecy is to prevent the fraudster from knowing that there's an investigation going on and concealing evidence or otherwise taking steps to insulate themselves from liability.
Why did you focus on this type of law to, focus your practice on?
Well, I was fortunate enough to be involved in the drafting of the 2007 law, which gave New York State a False Claims Act. And
how were you involved in that?
It was a collective effort by a number of folks. I was working in the New York State Assembly, and the Attorney General had this bill, and it was tweaked and tinkered with, and eventually, with the leadership of Speaker Silver and others, and at that time Governor Spitzer, it was passed in 2007. And then, as I mentioned, in 2010, it was improved to allow for the type of tax cases that I alluded to before, and I was involved in that as well. And to me, it's a perfect public-private partnership.
Okay.
It's a win-win for everybody. The only people that lose are the bad guys, so to speak.
Which is?
The people who are presenting claims to the government for money, getting paid by the government for things that they shouldn't be presenting claims about, either excessively or not in the first place.
It's interesting because, you look at, and this may seem like it's way off topic, but you look at the dredging of the Hudson River. GE was approved by the EPA, Environmental Protection Agency, that they could go ahead and dump their chemicals into the Hudson River. Then all of a sudden, 30 years later, 40 years later, they say, government says, oh no, you couldn't have dumped all that. And GE says, but I had your permission. Well, not anymore. And now you have to pay millions and millions of dollars to clean it up and dredge it. And, so, when is it the responsibility of the government to say, oh, well, we don't need to have the private sector, we don't have to hold the private sector for the mistakes of the government. We don't, hold the private sector responsible for the mistakes of the government.
I don't know the GE case perhaps as
No, but I'm
intimately as
talking
you
about
do, but
when you talk about submitting a false claim, and the government approves it, and the government says, okay, we didn't know it was a false claim, but we signed off on this. Then why is it
anytime a claim is submitted to government,
why is it the honor system? It sounds like
it more or less is the honor system, at least at first. Anytime a claim is submitted to the government, and I'll use a Medicaid claim as an example, the healthcare provider must certify that they are familiar with the regulations that the government has, and they have complied with the regulations for the submission of these bills.
Oh, so there
to the
is
letter.
something to sign?
You have to specifically sign. In order to get a check back from the government, you specifically have to say, I did things according to Hoyle here. So when that doesn't happen,
Okay, so I didn't know, you didn't explain that, about signing a stipulation that says, I understand that what I'm submitting is truthful and valid.
Yes, because look, the government doesn't give away money for nothing. You have to say, you're not supposed to, and they typically don't. You have to be able to demonstrate to the government that you've done things right.
So that's where the person who's submitting the false claim, the rubber meets the road, is when they sign that stipulation.
That's correct.
Oh, okay.
Yeah.
Well, now that makes it. Now that's all clear to me.
There
Okay.
you go. Now you
Which
can be
is-
the lawyer also, Mark.
which
Be
is a
the-
good way to end.
Don't feel
investigative
bad, Mark,
requirement.
because again, many, if not most lawyers have very little familiarity with this. Its popularity and its prominence is growing as there are more and more cases, because after all, everybody would like to be Dr. Feldman. But you know, on the other hand, it's really a good way for the government to be made whole, where they deserve to be made whole.
Rich, you know, it was very informative. I want to thank you for not only coming on the Jewish View, but doing some good work for the, like you say, correcting a lot of falsehoods in the world and in New York State. And continue good work and do it with good health.
Yes.
Thank you, Rabbi.
Much continued success.
Thank you, Mark.